Good morning. Thank you for your invitation. I wanted to talk about MIPS, but someone else took that topic, so I have the less sexy topics. I did take a quick look at the 1,250-page final rule for 2018, the Medicare physician fee schedule, which is the division where I used to work, actually. I did my tour of duty and got out honorably. And it will be published in the Federal Register next Wednesday. Right now it is available public display at the Office of Federal Register website. Really, other than MIPS, not much has occurred or has been finalized that affects us any differently than really others. Today, what I'll do is just focus on really some of the key aspects, and then I want to also talk about a couple of other topics where I'm seeing activity in the federal environment, meaning enforcement by Medicare, OIG, Department of Justice, okay, so that you can see what's happening in the trenches elsewhere or nationally, so that you can, report back or, think of, I guess, strategies to address them. So, first and foremost, a whopping raise of a dime in the conversion factor. And even though the relative value units, the RVUs, overall increased only by 0.41%, that's less than 1%, for all of the specialties, somehow our codes, we were able to obtain a whopping 1% increase compared to last year. Now this is average, we're only talking about relative value units. As you know, it's a budget neutral process, so like a balloon, if it bubbles someplace else, then someone's losing elsewhere as well. And just to level set, I put in here for your reference and cocktail reception discussion, the actual Medicare fee schedule formula, okay? So as you can see, there is a rhyme or reason to how they come up with the dollar amount. So you have the dollar amount, which changes every year, and then through, if you recall the Harvard study, the relative value units are computed using data from the specialty groups. Furthermore, CMS accounts for price differences among regions of the country. GPSI, Geographic Practice Index, Practice Cost Index. So you would multiply the GPSI for that area with the particular RVU category. And of course, even though there is overhead, which CMS really rarely shares with us, you have three key direct components of the fee schedule, and that's of course work RVU, physician time, practice expense RVU, medical equipment, clinical labor, supplies, and then malpractice RVU. Overall, the work RVU consists 55% of the work RVU, 40% of the practice expense, and 5% of the malpractice RVU make up the fee schedule RVU for particular codes. So that's how it's on average divvied up. 55% work, 40% practice expense, 5% malpractice. So clearly a very, very significant aspect, even at 5%. And so you would basically multiply the RVU, relative value unit, that's computed for these categories with the geographic cost index. You sum those up, multiplied by the conversion factor, and that's how you get the dollar amount for each CPT or HCPCS code. Now, in the regulation for next year, effective 2018, January, the Incident 2 discussion was really related to chronic care management and other management codes that really don't involve us. However, I will tell you that 2 years ago, CMS tweaked with this regulation a little bit, and then last year they actually proposed, if not threatened, incident to focused audits because they believe that this policy is lacking oversight. And just to level set, incident two is where I go and see my physician. Let's say I'm a Medicare Benny. Physician sees me, probably triggers an E&M, evaluation and management, says go see my nurse and my nurse will give you a shot. I go see the nurse and the nurse gives me an injection. Under the incident two policy of Medicare, the physician may bill for the E&M that she personally performed on me, and the physician may bill for the injection that the nurse provided as long as the physician directly supervised that, okay? And I was told when I worked at CMS Central down here in Woodlawn that this was the ultimate deal maker because the earlier versions of the Medicare law in 1965 or 64, Medicare only paid for things you did, period. And of course, that does not reflect current medical practice today, and that didn't reflect it then either. So this concept of incident two was created so that in essence, physicians may be reimbursed for things that they do and for things that they supervise. And this really has become a fundamental principle of any insurance, really. I mean, they might not call it incident two, but even commercial payers, other non-Medicare payers like Medicaid, they focus on this concept. Hey, we will pay you for things you did or things you supervised. And even though when I worked in this regulation, 2001, effective 2002, and finally revised it to clarify some of the components, a lot of people were upset. They talked about, wait a minute, I'm the attending. I should be able to bill for everything that my patient receives. I don't care that I'm in a vacation in Europe. It's my patient, I get to bill. And of course, the OIG and DOJ and the plaintiffs bar had a feast with that, and so we saw a lot of whistleblower lawsuits and key toms when this incident two regulation was revised effective 2002. But lo and behold, it's still happening. I dare say, at least 20% of all the key tom cases that come to me, it's some form of incident two involving physicians, okay, involving physician practices of all specialty, involves some form of incident two in that it involves non-physicians performing the service and involves physician supervision or the lack thereof. It's still causing a lot of confusion. I remember at CMS when this was revised, I gave a speech at, I think it was Chicago. Maybe it was an AMA speech. And before I could even say one word, someone in the back said, excuse me, Mr. Kim, before you go to incident two, can you please tell us about incident one? So even in 2002, it caused tremendous confusion. And this is now 52 years old. It's a 52-year-old policy. So anyway, hopefully today we can finally understand so that we can hopefully avoid the audits. But if we do, if we or our constituents face audits, we know exactly how to address them. So the key component of incident two is that there has to be an initial professional service. Now, it can be, of course, a physician who triggers that service, but a little known secret, it could also be a handful of Medicare non-physicians, okay? So a Medicare nurse practitioner can treat me, trigger an E&M, and then supervise the nurse giving me the injection. Medicare physician assistant, clinical nurse specialist. It's like a handful of Medicare-enrolled non-physician practitioners also have this capability. And not many people know about this, and I don't know why, because this can clearly expand access to your patient population, generate revenues lawfully, right, additional revenues lawfully, but it's something about that payment differential, because as you know, Medicare does not pay the full 100% to non-physicians, usually 85%, and so they want to keep that extra 15%, and that strive to collect the 15% is what's attracting the scrutiny. But anyway, professional service triggers it, and then again, whatever that is necessary. Obviously, we're not talking about experimental or otherwise non-cover services. As long as somebody, in fact, it doesn't even have to be the ordering person. If I was a doctor practicing with my partners, I can see my patient, trigger an E&M, go to the hospital to do rounds, and my partner can directly supervise the incident to service. Now that means my partner's name has to be on the claim. The partner's MPI has to be on the claim because I wasn't there. But either way, there is that flexibility. But because of that flexibility, again, some people are very upset, especially the oncologists. Also, my partner might feel, I don't know your patient. I'm not going to put my name on that. I'm actually certifying that I find this service to be medically necessary. I don't know. It's not my care plan. It's not my patient. I don't want to do it. Oncologists met with CMS. CMS response was, we don't care. We want the person who was there supervising, we want that person identified, we want that person's MPI on the claim, okay? Now, the key component for a lot of the litigation that we're seeing, and again, it's plaintiff's bar, especially now that CMS has 2 years in a row, so 2016, 2017, indicated that we want more oversight. There are more plaintiff's lawyers, more employees learning up about Incident to. And in particular, they're focused on this direct supervision concept. Very simple words, right? Direct supervision. Unbelievable permutation of definitions. If you break it down, it's just 2 requirements, okay? If you want to bill for incident to service, you must furnish direct supervision. How do you do that? 2 requirements. 1, the supervisor must be physically present in the office suite, okay? What is an office suite? Conventionally, think about your office or your doctor's office. Reception area, waiting area, patient rooms, administrative offices, all physically joined together, classic office suite, right? Well, now, especially with advancement in technology, that's not always the case. I might have offices in suite A, B, and F. I might have waiting room on the 1st floor, treatment rooms on the 3rd floor, okay? Well, because CMS could not possibly address all of the factual permutations, they specifically in the Federal Register instructed us to go to our local MACs, Medicare Administrative Contractors. And to my skeptical surprise, they have been responsive. They've been very responsive. We may not like the answer, but they've been very responsive. And I know some people say, well, I'll ask for forgiveness, not permission. I don't recommend that for Medicaid. I think we need to ask for permission because asking for forgiveness is very, very expensive. But I'll tell you, in my experience and in my client's experience, if you have different suites on the same floor, even though they're not physically next to each other, no problem. Every MAC has been okay with that, provided that you're the tenant for all 3 offices, okay? So you have a corporate practice, so you're the tenant for all 3 offices on the same floor, not touching each other, no problem, 1 single office suite. Now, different floors, I don't know why. Some MACs say no, okay? It may be the change of the wind. I mean, if a new MAC comes into your jurisdiction, ask them again. They might change their mind. But some MACs say no, but some MACs say no problem, again, provided you are the tenant for all 3 offices or all offices on the floors, okay? Now, different buildings, though, no matter how close the buildings are, no MAC's gone for that. So it's not just physical proximity or just same tenancy. They are looking at basically within a single building, all right? Now, if you're making improvements, renovations in your office or moving and you're not quite sure, please think about asking your local MAC. Tell your constituents to also think about asking your local MAC because they will respond and that document will help you in an audit, okay? So first, physical presence in the office suite. Second, immediate availability, okay? CMS doesn't care if the supervisor leaves to go to the restroom. They really don't. CMS doesn't care if the supervisor leaves to grab a cup of coffee. They don't. And inherently, availability is transient, right? It's not fixed, okay? So if you're seeing those things, don't worry about it. More importantly, to try to nip any type of litigious employees' minds, try to explain to them that CMS doesn't care, right? Because then your employees will also know, and they're not going to start thinking, well, wait a minute, my doctor yelled at me today, and I know he took a 10-minute break. You could nip that in the bud by explaining to them, look, this is what immediate availability means, okay? And of course, people think physical proximity, right? I can see my nurse, I must be immediately available, right? But there's other forms of distance, shouting distance. I could hear my nurse yell for help, I must be available. My coinage, mental distance, right? I'm right next door to my nurse seeing a patient, but I'm also seeing a patient, but I really can't leave right now. I'm with a patient, and what I'm doing right now, I can't leave. I may not be available. So again, unlimited factual permutations, CMS deferred to the MACs on this issue as well, and they have been responsive. But again, I would not go to them for these transient issues. Think about systemic issues. The classic example that I could think of is your new space is dog leg right. Any golfers? It's an L-shaped form, right? So if I'm at the one end of the L and my nurse is at the other end of the L, I literally cannot see my nurse, I cannot hear my nurse. Okay, you might want to ask your local MAC if you're immediately available, okay? You might, of course, put in additional facts, but you know what? We're only about 1,000 square feet. I could get there in nanosecond, whatever. Put all those facts in, but consider the possibility that if you cannot see or hear your auxiliary personnel performing incident 2, that the auditors will, may have a feast with that. All right. So that's really the only situation where you might want to consider asking. But everything else, very transient, coffee breaks, bio breaks, no problem. But again, talk about that to your staff so they don't get any ideas either incorrectly. All right. Now, CMS has, of course, put in limits for a lot of other services. A teaching physician can only supervise up to 4 family practice medical residents. A radiologist may supervise only 3 independent diagnostic testing facilities. Anesthesiologists, only 4 medically directed cases involving CRNAs, right? Incident 2, no. CMS did not pose any limits. This is probably why several years ago, the Post or the Times or the Journal had an article about some doc who billed 26 hours in a day. I mean, clearly that person didn't understand the concept of incident 2. Because the doc is not physically performing services 26 hours a day, but rather with support staff, the bills go out under the doctor's name, and so when you add up the E&M codes, that's what it looks like, right? But despite that type of publicity, if you will, CMS has not changed its policy and has not posed any limits. And I'm not aware of any local coverage determinations either. If you do, please share with me, but I'm not aware of any NCDs or LCDs limiting the number of incident to either. And so that's also another fact that I think you should, every physician should share with their staff, because they may think, there are 5 of us here. How can he possibly supervise all of us? Well, Medicare thinks it's okay. I'll give you another anecdote. There was a case out of Hawaii about a decade ago, oncology practice. Because of chemotherapy, there's a lot of oncology cases for incident 2. Quite frankly, radiation therapy is covered separately under the law. Chemotherapy is not listed. So chemotherapy is only covered because of incident 2. And it is the #1 Medicare expenditure for incident 2. Anyway, the doctor was unhappy with his contract negotiations, and one day noticed just claims being filed under his name for patients he never saw. So he and his lawyer pursued a whistleblower action, a key tom, and the U.S. District Court judge in Hawaii basically asked him 2 questions, along these lines. Hey, doc, were you physically present during those days? And sure enough, he was assigned to be the supervisor of the chemotherapy clinic on those dates that the claims were filed under his name. And the judge said, okay, were you immediately available on those days? And it just happened that this was not a very large clinic. So anywhere you could see all 4 corners of the wall. Corners of the wall? All four walls, all 4 corners. And so the judge said, dismissed. There is no false claims here. You are physically present and immediately available. Now, I'm not suggesting that we don't tell our doctors that they're supervisors. I mean, but you can see, you don't even have to know that you're the supervisor. As long as you met these two criteria, you're golden, all right? So, I recommend, ideally, each patient's chart for that date of service should include the supervisor's identity, ideally. But the auditors have been also okay reviewing physician supervision calendars, looking at sign-in sheets, okay? So as long as those other documents are kept in your ordinary course of business, you can submit them as proof of supervision, okay, to Medicare audits or any other auditor, private pay, Medicaid, or whatever. But anyway, this is very important because CMS is continuing to focus on additional compliance. So I suspect for next year, they will issue proposals finally on Incident 2. They've already suggested maybe adding a modifier whenever you bill Incident 2. I suspect I2, get it? They also talked about having the RACs audit Incident 2. They talked about making us enroll all of our staff, even though they're not Medicare non-physicians. So if we use a medical assistant, we have to enroll that person. If we use a registered nurse, we may have to enroll that person. They've already talked about all kinds of stuff. I don't think we can avoid it. They put too much time in this. They invested in this. So it's a matter of years, I suppose. We'll see regulations on this. So hopefully we can prepare, but also maybe, through comments, we can convince them it's just not necessary. Yes, sir?
Yeah, while we're on this, just a quick question. If in Virginia, we can supervise nurse practitioners, is a cell phone call away sufficient? Because if you go on a conference, a CME conference, or you're in surgery, can you rely on your nurse practitioner to be seeing patients while you're away at a conference if you're only a cell phone away?
Okay, so if I heard you correctly.
If I'm on a conference and my
Right.
nurse practitioner's left back to cover for me, I'm a cell phone away. Is that allowable? Or must I be present, more present than that?
Right, so you will not be able to be identified as the supervisor because you were not physically present. I thought you were asking whether the nurse practitioner could be identified as a supervisor, and the answer is yes, as long as she or he was actually physically present in the office suite.
Nurse practitioners have
Right.
to have a
Yeah,
supervision.
you have to be physically present in the office suite, even if you are literally phone call away, next building. Unfortunately, they're looking for physical presence.
Okay.
So the nurse practitioner, if he or she is enrolled in Medicare, could be the supervisor of Incident 2 services. And by the way, even though the nurse practitioners and physician assistants receive 85%, that only applies to professional services. So if you're involved in injections, it's part of what they call the no work RVU pool. So the reimbursement is 100%. So you're not really losing much just because you're having your non-physicians become the supervisor. Okay? If it's additional E&M, sure. Incident 2 of a nurse practitioner will be paid at 85%. But for these technical services, just if they're Incident 2, and even if it's supervised by a nurse practitioner, Medicare will still pay you 100%. Now, you remind me, however, of another issue I want to raise. I do know that the association is working very hard to clarify whether or not podiatrists may be the supervisor of PAs or nurse practitioners for their own benefit, meaning it's not Incident 2, right? You have a nurse practitioner or a PA seeing patients under state law, and they want to drop the claims under their name, right, and receive 85%, right? The question that has been raised, and the association is aware of it, can a podiatrist be the supervising physician for that purpose, okay? Well, CMS usually defers to state law, but for some reason, the statute lists only certain types of physicians, okay? Yet, when they implemented the statutory provision, they made it even more vague. So the association is still trying to work to obtain clarification as to whether or not we can be the supervising physician for the PA benefit and the nurse practitioner benefit when they bill directly. But for Incident 2, there is no such restriction, okay? Unless state law, for some reason, restrict podiatrists to supervise Incident 2 services, performed by, you know, PAs or NPs. Medicare does not have that limitation. So again, let me just clarify. For incident 2, podiatrist may be the supervisor, but for PA NP benefit, where they bill directly using their MPI, it's not clear yet from CMS's perspective anyway, whether a podiatrist may be the supervisor. I do know that some states have made it more clear and excluded podiatrists, but not every state. But those are two different issues, because incident 2 is with the podiatrist dropping the claim. With the PAMP, their MPI gets dropped in the claim. Okay, and that's where the supervision is still murky for Medicare. Yes, sir.
Under the incident 2 rule, must it be a licensed or certified person, such as a registered nurse or medical assistant, or can it just be somebody that you've trained in your office, say, to do nail care that is covered by Medicare?
Okay. So technically under Medicare, it can be literally anybody. I think the language in the Federal Register is medical assistant to another physician. How do I know that? I wrote that in there. However, the OIG hates it. For a decade now, the OIG includes in their annual work plan audit of incident to services, qualification of auxiliary personnel, you know, because the OIG, for whatever reason, believes that incident 2 is a loophole for those clinicians who lost their license, who lost their billing privileges, right? That's not it. In fact, the regulation clearly specify that all applicable other Medicare regulations and state regulations must be met. But still, OIG believes that it's being abused. So I guess the short answer is if the state requires some form of licensure, registration, and or certification for the service that you want to delegate, you have to meet that. Okay? But absent any state requirements for Medicare, I mean, I took over this policy after a gentleman started this policy since the 60s. His name was Robert Ulikowski. And he used to tell me, the doctor can supervise the janitor. Because that's exactly how it's written. I mean, it literally is that expansive. Why? Because it's the doctor's license. It's their delegation authority. Medicare does not dictate the practice of medicine, although if you don't pay for it, you kind of wonder. But anyway, they don't dictate the practice of medicine. They're an insurance company, so they specifically did not want to specify whom you can supervise, at least for incident 2 services. Okay? Yes, sir.
So if the state doesn't actually address by statute medical assistance, does then the federal government have rules and guidelines that would guide you, or do they stipulate that the state must address it first, one way or the other, and then they would clarify?
For incident 2 anyway, they defer to state law, if any. So the clinicians performing incident 2 services, Medicare defers to state law. So whatever state requires, those clinicians performing incident 2 services must meet them. If none is required, then none must be met. Now, there are other services where CMS is more specific, okay? But for incident 2, no. It's literally your license, your delegation authority, subject to any restrictions or prohibitions by state law. Okay. Yes.
Okay, so I can be clear on this. WPS when it comes to routine foot care, has put in writing that a medical assistant cannot do routine foot care. Now, the incident 2 sounds like if we can do a janitor, oversee a janitor, how does
I don't recommend it, by the way. Don't quote me on that.
I know what you meant. Okay, but they're more open and more broad in their definition of that. So, and if CMS is deferring to state law, and there is no state law on this, how does this work now?
Right. So we're talking about rogue MAC contractor policies, and that's always been a problem. And by the way, because more MACs are issuing bulletins or policies, that's probably not even an LCD. Is it an LCD?
It will become an LCD, but that is not yet the law.
Right. So they try to do LCDs, do the draft, get slaughtered by the comments, they pull the draft LCD, and then they put it in their monthly, bulletin. That's what they do. Pardon my Korean, but they're assholes. And CMS knows about this, okay? But they will only intervene under certain circumstances, procedural. So if you can show that they violated their mandated procedure to issue policies, then they could come in and intervene. However, if it's a judgment call based on cost or clinical data, CMS will not intervene, okay? And because of this, what's been happening is there are more applications for national coverage determinations than any decade in the past. Why? Because people are sick of these local policies, so they go to CMS and say, we want an NCD, so that there'll be uniformity, and we could rein, unless you can rein in these rogue contractors, we want an NCD that's applicable to all of the land. And so they've told me, I've actually filed a couple, and they told me, Paul, I don't know what's going on. We've had more applications than I can remember. And I say, it's because of your damn contractors. They're doing all this, crap to try to save money, and they're not following the policies, but the auditors are looking at their policies and auditing the providers. And you won't intervene because you think the procedure was followed. So yes, I'm aware of that, and that should be fought, or at least let CMS know of that, especially if it's an LCD. Because even if the claim is denied, CMS's regulations, and I'll talk about this in a bit, say the ALJ, the Administrative Law Judge, is not bound by LCDs. So they even realize the regulation and the NCD's rule, and yet they allow these contractors to issue all this kind of stuff to deny claims. So, maybe the association could pick it up depending on how large the issue is, but those things should be called out, and hopefully CMS will intervene. Again, they will intervene if they see procedural issues. If they see a judgment call, hey, we think this is $10, not $12, they're not going to intervene. Okay? All right. So now let's talk about why we care about all this crap. The 60-day rule. It basically says we must, so we are all aware of thou shalt not file false claims, right? Make sure all the claims are accurate, complete, but now thou shalt not keep overpayments. So it was part of the Affordable Care Act, and so we must report and return any overpayment within 60 days of identification. These literally are the words in the statute, okay? Very simple. Now, even though it was enacted in 2010, CMS took a couple years to issue proposed rules, and then finally last year, March 14th, the final regulations became effective, okay? By the way, this is not new. When I was at CMS, there were 2 additional regulations to try to impose this 60-day rule. But not surprisingly, they got slammed, and they thought we need a statute. So now, it's bad to obviously file false claims and ask for money, but if we keep monies that we know are overpayments, the same sanctions of a false claims apply. So this is called, affectionately, the Reverse False Claims Act liability. What does that mean? Treble damages, triple the amount of the claim, plus anywhere between $11,000 to $22,000 per claim. So let's say you see 50 patients in a day, and they're all subject to this. That's 50 times $11,000 to $22,000. Okay, this is why we care. This is why we care that the Incident 2 rules are followed. This is why we care the local policies are followed. And there was this other sort of history to this, but basically there's a 6-year look-back period But luckily, it doesn't go back to 2010, it goes back to 2016. So my recommendation, spring cleaning, going back to March 14th, 2016. Because to me, this is no longer, you know, well, I don't see it, so I'm not going to do anything about it. I think it's more than that. So let's break it down. Overpayment, we all know what that is, right? Duplicate claims, they even say medical necessity. But really what they're talking about is any overpayment that their auditors didn't catch. That's really what they're saying. It's self-identification. If the RAC didn't catch it, OIG didn't catch it, ZPIC didn't catch it, well then you better make sure you catch it, going back to 2016, okay? And I'm not talking about claim correction. Oops, wrong date of service. No, we're talking about true overpayments, duplicate payment, non-compliant with LCDs or NCDs, lack of documentation. I mean, these are very subjective issues, but it's self-reporting. Now, identification, luckily, first of all, they went back 6 years, even though they had proposed a decade. And they did listen to comments, so now we have 6 months to identify, and then 60 days after that to report and return, okay? CMS gave everybody 6 months to identify. So what does that mean? A claim gets denied. Wait a minute. This is very similar to some of the claims I filed last week and I got paid. I need to look at it. RAC comes in, asks for 20 records, denies 10. Wait a minute. I have other similar claims that look like the ones that the RAC's denied. I have to identify them. So 6 months of self-identification. It's no longer voluntary. I think this is a duty to not just refund overpayments, but duty to actually go seek and identify. So at least now, where the 6-year look-back period hasn't fully extended yet, it begins on March 14th last year, the sooner we can start our spring cleaning, going back, we can look at just 6 years in the future, right? So this is beyond, there was never a duty to report before, there was never, you know, I mean, if the RAC comes in and saw $10,000, you could stop. Oh, thank goodness, we dodged that bullet. But no, if you see anything that could possibly lead to other overpayments in your bank, you have to go identify it. Yes, sir.
So there used to be a significant differentiation between fraud and abuse. And I think that is, or what came into play there was intent. So what you're talking about now is us being prosecuted as if we committed fraud for something that could potentially have been abuse as a result of our not understanding the rules. Is that correct?
Fraud is not an element here. It looks like it, it feels like it, tastes like it smells like it, but it's not an element here. It really is technical overpayments. Maybe we got them because of fraud, but we could have just gotten overpayments because of pure clerical error, right? Now, you're right. Because this is, you know, this is nicknamed the Reverse False Claims Act liability, you would think there was some fraudulent component involved. No, they didn't make that link. This is called a self-reporting refund policy, and yet they imposed the sanctions associated with the fraud law. That's why this is so detrimental. I mean, even now, we could just fill out a form, right, off the MAC website and return an overpayment. We've been able to do that for decades. Well, now we have a duty to do that. We have a duty to do that, and we have a duty to go find it to do that. At least going back to March 14, 2016. So hopefully it's not fraud. I mean, I would hate to think that we committed fraud to keep the overpayment. But even if it's not, because we had the sanctions of a fraud law, that's why we care about this. And that's why we have to comply. And that's why we have to talk about it, to let the staff know. And this is why the plaintiff's bar is, you know, celebrating right now. They now have another avenue to sue doctors. Not about what you did affirmatively, but what you Didn't do. Now, technically, you're supposed to report to your local MAC, just like any voluntary refund that we may have been experiencing in the past. But depending on the issue, you may want to consider other things. OIG is known for kickback, but they also collect refunds for medical necessity. The OIG, they can negotiate with you, pennies on the dollar. Your MAC cannot. They want to, but they can't. No statutory authority. CMS can't either. The only reason why CMS gave hospitals 68 cents on the dollar 2 years ago is because the AHA filed lawsuit, right? They allowed all the hospitals, pursuing the RAC appeals, a settlement of 68 cents on the dollar. But they can't do that in normal course of business, unfortunately, and neither can their contractors. But OIG can. So depending on the facts, maybe you go to the OIG to cut a deal, now that you found something. One thing to be worried about, the OIG has the CIA authority, right? Corporate Integrity Agreement Authority, where up to 5 years you pay for your own self-monitoring, right? So that's their teeth. They also have the exclusion authority, potentially. If they think it really was fraud and it was so heinous, they might exclude you as well. So there's some pros and cons of going to OIG, and therefore very fact-specific, fact-dependent. CMS has their own more recent protocol, but it's only for Stark. And if it's Stark, you have to use that protocol. They're delayed, okay? They're tremendously delayed. So I can't tell you what experience the medical community has been seeing. You know, they have been low on the penalties, but that's about it. They haven't really forgiven much, and yet we haven't seen enough settlements to get a sense of how CMS is handling these things, but it's only Stark. And then, of course, you have your Department of Justice, your state U.S. Attorney's Office. Yes? Unfortunately, no. Yeah. But having a good one will count, because they can mess it up and it's still your responsibility. Yeah. I mean, this has unfortunately become a very expensive cost of doing business with Medicare, this law. Yes, sir. You know, I was thinking exactly the same when I saw the proposed rule in 2012, because they included in, as an example of an overpayment, an external government contractor finds an overpayment. And I thought, why is that in there? This is a self-duty issue. Well, in the final rule last year, they clarified it. No, 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 no. We're not talking about what we found. We know you have appeal rights. However, if based on what we found, you think you have other things that are similar, you got to go find that, and you have 6 months to do that. So it's up to them to identify the problem. Well, they might have on a sample, but if you believe that there are other claims, similar claims out there that may have not satisfied the NCD, for example, like you said, now you have 6 months to fully identify and then 60 days to report and return. I'm just asking if the predicate is the audit first. Do I need to be audited? No. Oh, I see what you're saying. No. Right. No, you don't have to wait for an audit. It could be one way you find out, but there could be other ways where you find out, right? Maybe one claim got denied by your local MAC, and you wonder, why is this being denied? Oh, I get it. Wait a minute. I just did 10 of these last week, but it got paid. I got to look into that. The discovery is, that's why CMS put all kinds of examples, and that's why I got confused, honestly. I said, why is an audit there? That's an external issue. They were saying that's also a way for you to discover other overpayments. You could stumble on it. Someone could, come to you, a staff member can come to you, a patient can complain to you about it, or the government can audit a part of it, which now alerts you to other overpayments. Yes, sir, in the white.
In that process, if you happen to find that they were underpaid, can you resubmit, or does that only apply to overpayments?
If it's an underpayment, most likely the MAC will say, refile the claim if the claim filing deadline has not expired, so 12 months. So if you can refile within 12 months, sure, file that corrected claim and get the additional money. But the 60-day rule is only for overpayment. Yes, sir.
On that same example, the RAC comes in, they find something wrong, you just submitted a bunch of additional claims after that. But you feel the RAC is wrong, and then they say you follow the LCD or the NCD. In that case, are you obligated to have to go back?
Great question. And this is why it's important to actually stop and think about this, because I have been involved, and I have been in a situation where, you know what, client, I think they are wrong. Okay, we will appeal this, and because it's not been identified, the 60-day does not toll, right? It'd be helpful if you had a lawyer write that to you for your files, right? But yes, absolutely. If you disagree with the denial, then no overpayment, additional overpayment has been identified. Now, then the question is, let's say you go through the appeal and you still lose, you know, we can talk more, but it depends on why you lost, you know. It also depends on why you stopped appealing. I mean, at some point, it's just not worth paying $1 to collect 50 cents, right? So if that's the decision, a lawyer can help you craft an internal memo for your protection saying, you know what, I stopped appealing this, but I still disagree this is an overpayment. I'm going to stop doing it, but I disagree this is an overpayment. Here's why, and end of file. Or if you continue to appeal and it finally still gets upheld, then you have to now think about, okay, do I have to go look at other things? And probably yes. If you exhausted all your appeals and they still say, nope, this is an overpayment, then yeah, you have no other reason to say it's not, so therefore you do have to look around for others. Yes, ma'am.
At what point is it worth it? A lot of times, from time to time, I'll get a letter from CMS or whatever saying that they're overpaid me $56.20. Sometimes I don't even delve into what it's for. I just write a check and just send it because I just don't want to be bothered. But in writing that check and sending it, which I think a lot of us probably do, are we is that an admission of guilt? And is that saying that we know that this overpayment is for using A, B, C, and D, and we're supposed to go back and look for that? Is it better to try and fight it, or, you know, at what point is it not worth it?
Okay, so before March 2016, I think the normal practice of cutting the check and hoping they'll just cash it and go away was fine. In fact, I advise clients that. But now, beginning March 2016, we have to find out why there was that overpayment, even if it's $50. Because to the extent there are others, and there's no de minimis. I mean, it could be $1, and technically, we can be hit with all the penalties, right? But the idea is, find out why it's an overpayment. If we don't think there's any other claim like that, then that's fine. We conclude that, and we file that away. But if we do believe they're out there, we have to look. It could be 10, it could be 1,000. And so the $50 in volume becomes sizable. Yeah. No, no. So if you disagree, and yet you don't want to spend, like I said, $1 to collect 50 cents, that's when a file might be helpful, right? So work with your, I don't know, accountant, lawyer, whoever, some third party, to draft a file saying, you know what, I disagree with this, here's why, but appealing it will cost X, Y, Z, I'm going to pay it, but I do not find any overpayment. Exactly. Because that way, you know, when there is a separate audit, right, when there's a separate audit, you can show that you didn't just ignore it. You know, you can show that. Furthermore, there is this concept of advice of counsel defense. You know, if you did receive advice from counsel and it turned out to be wrong, you actually can raise that as a defense. I'm not talking about, you know, I had shoddy counsel. It's actually a separate concept, especially in health law, because there's a lot of, you know, lawyer involvement before an action is taken. Again, permission before forgiveness. So there's a lot of documentation that, especially the bigger systems, request so that they could have the files to show an auditor. So the advice of counsel defense is effective. But in that situation, one claim, some other format should be just as good. Maybe not even a lawyer, but an accountant or some third party where you can very clearly and comprehensively lay out why you disagree, but also why you're not going to spend the money to appeal it. Yes. Yes, sir.
Yeah, sorry for interrupting. I'm just wanting to remind everyone to please use these microphones because we're recording in the back. Thank you. And if people can't get to the mics because it is a little bit crowded, if you could please repeat the question. Thanks.
Sorry. This is being recorded? I didn't realize. Sorry.
Thank you.
CMS is the best agency in the entire federal government. Okay, so the last place you might want to try to negotiate is with DOJ. And yes, go ahead.
Just clarification. So you said if you disagree, you cut the check, like John Dell said, and you send a letter. You're saying you need a third party? In other words, you need an outside counsel in order to do that? Or can you just write the letter yourself saying, I disagree with this finding?
Yeah, there is no one way to do it. The government didn't tell us what to do. I'm suggesting, having worked at the government and worked outside, that there has to be some documentation of consideration. Sure, it'd be better if you had a third party, right? It's more compelling. That's obvious. Otherwise, it's self-serving, right? But depending on the facts, it may be just as good for you to lay out the reasons why this is not an overpayment and why you don't think you have an obligation under the 60-day rule. Because that way you can document contemporaneously that you've addressed this issue, you thought about this issue. It's the fact that you didn't think about it and didn't document it, that's when they just assume you were trying to hide it, right? So that's the idea. You want to document that, yes, there was consideration regarding this issue, and document it. Look, if it's I don't know what the threshold is. I mean, some practices, $1,000 is too much, and they'll hire a lawyer to document that for them. Other practices, $10,000 is too much, and that's when they'll hire a lawyer. It varies. I can't really tell you, when you have to get a lawyer or an accountant or whatever. I'm just suggesting that you document it, period. But clearly, you want to be more than self-serving, and depending on the facts and probably the dollar amount, that's when you may want to consider, do I need third-party involvement for credibility purposes, right?
But do a lot of people...
I didn't hear any of the stuff you said from the seat to the mic.
Do a lot of people self-report? Do you find a lot of people do self-report?
Absolutely. Absolutely. Because doing it now will avoid this penalty. I'm dealing with a client now, very small client, but I've known them for decades. I said, fine, I'll work with you, but you got to do the heavy lifting because, we got to make it work. And it's not that amount, a lot, but the risk to them is tremendous. Treble damages plus this potential. And the facts are that even though they really did not have any intent, okay, it is so clear of a violation. I mean, it's rare to see that. They were totally innocent of their action. They did not know, but the violation is so horrible that it could actually might rise to criminal. They'll try it. They'll have to prove intent, and they probably can't. But then what's under criminal? Revocation, right? So they're concerned about being revoked. They're concerned about being excluded. So that's why this amount, even though it's not that big, they want to pay it and they want to resolve it as much as possible. So yes, I get that a lot, and it's not just the bigger clients. Now look, everybody has a different spectrum of risk tolerance. I get that. You call me, hey, Mr. King, is this a problem? And I conclude, yes, it is. I will tell you, now it's up to you, right? I'm just your agent. I'm not telling you what to do. I'm just telling you what your options are, what the facts are. We can hang up and wish each other good luck, or we can work together. So just because you tell me, I'm not going to push to get things done, even to my economic detriment, because you have that option of enjoying your risk tolerance level, Or I'm going to retire in 1 year. I don't care. Fine. Have a nice day. Good luck to you. So, there's a lot of facts involved, right? my kid is doing my practice. I can't let this practice, be exposed to this. I have to take care of this. I got partners, who are young with kids in college. I got to keep this practice afloat. Everybody has different facts, but just because you find an overpayment, the law does tell you you have to return it, but I'm not going to, force you to do that. I may not be able to work with you, but I can't force you to do that. So the last place you could go to settle your overpayment is DOJ. They are probably the most flexible in my view. I mean, they will literally collect pennies on the dollar. The only risk is, and it's the ultimate risk, they have criminal sanctions. I mean, that's the thing. If your facts are such that it's a high dollar issue, but there's absolutely no intent that anyone can see from left or right, inside out, then you consider going to DOJ, okay, to get that settlement. So again, technically, you report and refund to your local MAC, but depending on the facts, you have these other places to go to as well to hopefully, pay a little less. Okay. Lastly, let's talk about the auditors. All right, so we talked about one policy that trips us up and has been for 52 years. We now talked about why it matters. Now let's talk about, even if we don't do anything, why we still have to be, on our toes. So CMS has launched, thanks to Congress, an army of auditors. OIU technically is not a contractor. It's a separate agency, right? It's like the policing arm of HHS, and they historically has been the auditor. Lately, they've been only auditing new regulations. So if CMS issues any new regulations for our specialty, wait for an OIG audit, because they want to see whether we're complying with those new regulations, okay? The ZPICs, they're fraud busters, right? Their overpayment assessment is always at least 7 figures, even for a physician practice. They will contact your state board of licensing and tell on you. They will tell other agencies, state Medicaid, CMS Central in Baltimore. If the racks bark, ZPICs bite. Why? I personally think because the ZPICs want the contingency fee arrangement. The racks, as you know, collect a percentage of what they find. ZPICs don't do that. Only Congress can authorize that. So I think ZPICs have ramped up their activity to show Congress, look what we found. Give us the same, compensation package. Personally, that's what I think. And I don't care if this is being recorded, I'll say it. The MACs, of course, are your local friendly contractor. They've been doing the usual audits. So these 3 entities are probably the most dangerous because, first of all, they have the authority to audit a random sample. What does that mean? They can extrapolate to the universe. So random sample of, let's say, 4 years, 100 claims. They find 20 claims to be denied. That's 20%. Then they say, give us our money back. Give us 20% of our money back from the past 4 years. That's why they're almost always 7 figures. The recovery contractors, yeah, they'll nip at your heel every 45 days, but they don't have this other authority. Plus, they got to talk to CMS, and they got to post it on their website before they begin auditing. So I know people are all concerned about the racks, but really the ZPICs and your local MACs are the ones to really be worried about. You have appeal rights, as you mentioned, and there could be strategic reasons to do so. Maybe you think it's an overpayment, not sure, but you want to appeal anyway to preserve your rights. Maybe you want to stop other audits. I mean, we could talk about all those different reasons, but once you decide to appeal, you have a 5-step process. However, little known fact, you have this other process that's parallel. Why? Because people like us went to Congress and said, listen, we need another forum because the auditors just don't talk to us. They're not very helpful to us. They don't tell us anything. We want an opportunity to talk to the auditors directly, right? Well, Congress came up with this rebuttal. They put it in the Social Security Act, the Medicare law. So when ZPICs or OIG would audit, we had 15 days to issue a written rebuttal directly to the auditor, okay? Well, it was horribly, it was horribly wasteful. One example, the ZPIC auditors came on site to the physician practice. By the way, they hired former FBI agents. So they come in, they pull the records. Some of the records my client didn't have. They go away. We gather the records, we submit it to them in a rebuttal. So much of the 248 pages were new records that they never saw, right? We overnight it to them. A couple of days later, we get a one-page, two-sentence letter. We reviewed your records, we uphold our denial. Now, pure luck, the FedEx slip was in that letter. So our package arrived there at 10:06 a.m. Their letter left there 6 p.m. same day. That's impossible. It's impossible for them to have reviewed 250-some pages of clinical records to come up with that, letter. So, I mean, they weren't doing anything. It was not, they were just, checking the box saying, yes, we did the rebuttal. So people complained. So luckily for the RAC program, CMS changed everything. They now call it the discussion period. Kind of like when HCFA was now CMS. They changed the discussion period. You now have up to 30 days. It's a one-on-one with the clinician, and it's been working great. So I don't know if you've faced this, but you can schedule a one-on-one with the medical director of the RAC, and many of the claims that were initially denied get reversed. Yes, I still hear complaints like, oh, Paul, I'm a neurosurgeon, and the RAC doctor was a orthopedic surgeon. This doesn't make any sense, You get some of that, yes. But overall, all in all, it's been effective. So if you have a RAC denial, do pursue the discussion period. I recommend it, okay? But remember, this is a separate parallel track. You still have this outline of deadlines to meet. So while you're doing the discussion period, forget the rebuttal, it's a waste of time. But do the discussion period, you still have to meet 120 days for the first appeal. And by the way, there's a form for that on the CMS website. Why? Patients have the same rights. So they have a very simple two-sided form. First appeal goes to your local MAC. Second appeal goes to a separate contractor called Qualified Independent Contractors. Third appeal goes to the ALJ. CMS has disclosed that about 2/3 of the RAC appeals get reversed at the ALJ. So you would think, then why are you wasting everyone's time and money? But nevertheless, the RAC audits are still happening. But the point is that some people say, Mr. King, I'll try the first level, and if it doesn't work out, I'll stop. I tell them, then don't even start, because you're not going to get anywhere until you get to the ALJ. 99% of the first level appeals get denied. 85% of the second level get denied. Only at the third level do you actually see some relief. Why? Because you have a person you're talking to. And this person will consider all of the issues, clinical, legal, procedural, whatever. The problem is there's a humongous delay. So it's like 2 years just to get a hearing. The law says they must, upon receiving your request, they must schedule the hearing, conduct the hearing, and issue a written decision all in 90 days. Now they're taking 700 some days. And so there's a lawsuit going on. CMS did revise the regulations, so they have attorney advisors making some of the decisions. I have yet to see some relief, though, quite frankly. I will tell you that I've had hearings recently where we filed them 3 years ago. So the pipeline is loosening up a little bit, but I haven't seen the benefits of additional attorney advisors being involved. You're unhappy there, you can go to the appeals council, kind of an appellate review, and then of course, finally, as someone mentioned, you can go to federal court to file a complaint. So this is your official appeal process for denied claims, regardless of who denied it. Now the recoupment, I'm not saying gamble on your overpayment, but the interest rate is set by law. It's like 10% right now, every 30 days. So if you don't want to incur the interest, pay your refund the money within the first 30 days. You can still appeal, but you pay the money so you don't incur any interest if you have it. That's what I normally recommend. No matter how strongly you feel about your case, it's just not worth 10% every 30 days. So pay the money and then pursue the appeal. Or if you don't want them taking any money from you and you don't want to pay them, you have to appeal within 30 days, the first level. Even though you have 120 days, now you got to do it in 30 days. They will not touch your AR. Some will by mistake, but you tell them they'll return the money. Second level, you're still denied. Now you have to appeal within 60 days, even though you have 180 days, previous slide, to continue the suppression. Now, they may not touch your AR, but the interest is still ticking every 30 days, okay? Now, in the good old days, when you had ALJ hearings in 90 days, this was not a problem because unfortunately, after the second level, you no longer can suppress recoupment. They will begin taking your AR, offsetting your AR. And now with the 3-year delay, you betcha, they're gonna take all your money before you even get your hearing scheduled. And this is why many of the smaller businesses basically close down. I think there were some stats about showing 20% of the small businesses, small meaning under the SBA definition of healthcare industry have basically shut down. You know, one, because of competitive bidding in the DME world, and two, because of the delay in appeals. Now, here's the financial part you got to figure out. Okay, they take your money, you wait, you persevere, you do your hearing, you win. They'll give you money back plus the 10% interest under the constitutional right of compensation for government taking, right? So if they recoup your money, you win, you get your principal back plus the 10% interest for every 30 days they had your money. I'm not saying this is a good investment, but I'm just saying that that's what happens. Now, you voluntarily pay the money because you don't want to take that chance of incurring 10%, and then you ultimately win, you get your money back, no interest. Why? Because when you voluntarily pay, even though you were demanded to pay, that's not a government taking. But if they recouped, that's a government taking. Good old Jefferson and Benjamin Franklin, right? That's government taking, so therefore they have to pay you interest. So think about that as well. I mean, I would love to get in on this investment, but you know, you just gotta have to think about that, consider the facts and so forth. Now, the other issue that's arising a lot more are revalidations and enrollment audits, okay? So we have to revalidate, fill out an A55B every 5 years. We have 60 days to respond. Please, please, please do not take this as just filling out a form. This is absolutely serious. They will not only revoke your number, but they will prevent you from coming back into the Medicare program, okay? You have other updates that you must comply with, right? Final adverse action, change of location, change of ownership, 30 days. Please, please, please do not miss this. Tell your constituents to not miss this. 90 days for everything else, any other changes that are part of the A55 application. Here's the problem. So if they revoke, it's technically within 30 days, but if it's due to a licensure issue, it can go retroactive. That means all the claims that you filed, over the payments. Any claims you want to file now, rejected. Any updates you want to file now, rejected. If you're appealing, do it anyway to show that you actually comply with the 30-day requirement to report a change. Do it anyway. Don't feel like, okay, I'm appealing this, I'm not going to do anything. No. If you have a change pending that you have to report, while your appeal is pending, file that. Even though it gets rejected, file it so you have a documentation to show that you comply with that rule. Okay? If you don't respond to a revalidation in 60 days, they will revoke your number and kick you out of the program for 1 year. You cannot come back until 1 year has passed. You cannot reapply. You don't talk about a felony conviction, they will kick you out for 1 year. If you have a new practitioner in your office and he or she did not talk about a felony conviction, they will kick him or her out for 3 years. You submit claims while you don't have all the licensures and so forth, or if there's some false information or anything else that's just not 100%, they will revoke your number and prevent you from re-enrolling for another 3 years. So this, again, is very serious. It's not just forms updating your information. No. This is, and the problem is, the contractors are using this as well to kick people out. First, they're using audits, payment audits, to kick out the small businesses. Now they're using this to kick people out. And if they were good at their jobs, no problems. But I know too many situations where had the inspector not turned left to the parking lot, but turned right to the office building, the inspector would not have revoked the number. This is a true story. The inspector looked left, saw a parking lot, revoked the number. Did not look right, with a sign and the building and everything was there. They revoked the number. Okay, this is very, very important, very serious, because I think this is another way contractors are trying to weed out fraud. Fortunately, there's an appeals process. I recommend pursuing this. If it's a matter of compliance issues, oh, you didn't have a sign, you didn't have a patient grievance policy, file a corrective action. However, if it's something ridiculous, like you don't exist because they looked at the wrong address or whatever, then you got to file for reconsideration. You do have an ALJ hearing in this process as well. Enrollment is a privilege under the Constitution. So that means when you have these hearings, there'll be a government lawyer on the other side. That's actually good news because they will negotiate with you. Okay? Claims appeals, the reps come in, they read their little thing, just no room for negotiations. These enrollment issues, because they're considered a privilege under the Constitution, the government lawyer will be involved, and you can negotiate. And I have negotiated most of these appeals. Okay, fine. Instead of going back to March 1, I can go back to May 1. Is that okay with your client? So you acknowledge that you did something wrong, yet there's still some room to negotiate enrollment effective date. Of course, depending on the facts. But do consider the appeals, especially if you do believe that they're not correct. And they are very sloppy, unfortunately. So I thought that those were the areas that I needed to report to you today. I know it wasn't the most happy of news, but hopefully people will realize that we are dealing with a government program, and there are real consequences. And even though we just want to care for our patients, we still have to dot our I's, dot our J's, cross our T's, and cross our F's. Thank you very much.